First, we want to update you on what is going on in the Sarah Boone case. We're expecting opening statements in that case as possibly this afternoon, but more likely tomorrow because things keep coming up. And this morning, something came up, a couple things. The prosecution upset over some discovery that they were handed apparently this morning, some JPEG images on a drive. So they have asked the judge for a hearing, a Richardson hearing. They are crying foul. Let's see what the judge says outside the presence of the jury that still hasn't even been picked yet. But there's Sarah. She's in the courtroom. We'll also find out about her snack request.
With regard to the Richardson hearing with regard to item 6 in the defendant's fifth amended reciprocal discovery list, the court is going to reserve and have that hearing tomorrow morning at 9 a.m. Defense is to provide an edited version of only the records that pertain to anxiety or their lack of thereof to the state before 9 a.m. tomorrow morning.
Judge, number 6 was cured by agreement.
Okay. Did that happen when I was not here?
No, it happened earlier while we were here.
Then what specifically was the Richardson violation for then, if it wasn't for number 6? And I apologize.
Number 2 was the 119 new JPEG pages, purporting to be from Winter Park Advent Health, and they're a little bit different than the 81 pages that I previously received.
Okay. So the ruling remains the same. Court's going to reserve, address the Richardson hearing tomorrow, and you were to provide an edited version of those records that you seek to offer into evidence. Mr. Owens, before 9 a.m. tomorrow morning.
Regarding the paragraph number 2, regarding the Winter Park Advent Health records, the 119 that we gave him this morning.
That is correct, sir. With regard to the witnesses that have been identified by the defense in paragraph 60 of the state's response, those witnesses will be excluded if not deposed prior to being called as witnesses, and the defense shall pay for any and all expedited transcripts.
All right, Judge, the same as should apply to them. There were 3 people that they gave us late that we didn't have before: Rachel Fenner, Meredith McCaskill, and Victoria Shelton.
State response.
Meredith McCaskill is an FDLE analyst that is substituting for an analyst that is unavailable during the trial period. So in an effort to not continue the case, we've got a substitute analyst. So that's our reason for the late disclosure on her. And who were the other 2?
Michelle Fenner and Victoria Shelton.
And those are the 911 dispatchers. If we end up having to call them, then that's fine. We will pay for the expedited transcripts. And what I would expect will not be lengthy nor expensive.
Okay. Has the FDLE analyst that was originally set to testify been deposed in this matter?
Mr. Cacciatore does not believe that the defendant ever deposed that person.
Okay. Any other positions, Mr. Owens? Okay. All right. State will afford the same opportunity to the defense as provided by the state to the defense. Court's going to be in recess. It's 11:27. Hang on. Juror number. Yes, let me address that. Can I have the thing again, please? If you all still have yesterday's sheets from jury selection, Madam Clerk has advised that jury services has told us the juror in seat 25 wearing badge 63 called sick child. The nephew that she cares for is ill and that she is not here due to caring for that child. He is not here due to caring for that child. State's response, if any.
For cause.
So stipulated. Juror number 25 wearing badge 63 will be struck for cause. We'll advise the jury services to call them and tell them they do not need to report. With regard to the or tennis motion as to Ms. Boone's request for snacks, the or tennis motion is denied. Ms. Boone is being provided all the same services as to any other inmate being transported for the purposes for trial. Anything else we need to address, State, before we report back to 23 at 1 p.m.? Defense?
No, sir.
All right, we'll see you all at 1 p.m. Thank you very much. Court's off the record.
Sarah Boone with a look there. She didn't react right away to the motion for snacks being denied. She will receive what everybody else receives. That is the ruling for the judge. If you missed it, she asked for some specific snacks in this case because she felt like she needed them. Let's watch that to remind everybody what she said.
You know, they get commissary there at the jail. She's asking that the officer that escorts her be allowed to bring her commissary. She's asking for 2 juice packs, 5 peppermints, 2 bags of chips, a bag of candy, and a bag of either cookies or a Pop-Tart to allow her through the day.
So that was the ask, and the answer was no. So there you have it. Eric Schwartzreich with us. Your thoughts on Sarah's snacks?
Hungry mouths do not get fed unless they ask. Let's snack on this. And she's asking for things. I mean, what's interesting are there things that typically you might expect a child might want. Peppermints, the other list. I don't know if there were cookies on there, but
yes,
here's
cookies.
the reality. Well, this case is a suitcase, and you know the lever being placed into a suitcase and the game of hide and seek. She is seeking the battered spouse syndrome. It's an evolution that's come a long way, which really is an extension of self-defense, the castle doctrine, no duty to retreat. So just that type of request, that permission. It's a very sad case. Can I have snacks? Can I have these peppermints? Can I have these cookies? Someone that was battered, someone that was abused. I mean, I find that aspect interesting. I mean, her look, she seemed more concerned about the snacks. I mean, she's on trial for very, very serious charges with very serious consequences. But she's saying, and the defense is going to try and say that she was battered. And if they lay that foundation and they put on the proper witnesses, the doctors, and you battle the experts, they're going to try and help towards her self-defense claim that she was in fear, that she had no choice but to do this. As far as the Richardson hearing, you know, discovery, fair play, the judge is trying to wrestle with, you know, whether or not discovery for the viewers, discoveries, all the evidence, police reports, everything the state or the defense is going to use in trial, that the defense didn't timely pursuant to our rule of procedure here in Florida, discovery, it's 3.220, turn over all the documents. They didn't do that. So in time, according to the state, and the judge is trying to wrestle with that. But it's a very drastic remedy. Courts don't like to do it, to exclude and to get rid of evidence.
Yeah, and he's postponed the decision on that. The Richardson hearing for tomorrow. Jury selection continues.